In today's episode, I talk with legal counsel Cory Sterling, and we get quite in depth on questions including, do you actually need to be certified on each piece of equipment in order to teach on that piece of equipment? Is maintaining your certification a thing? Like, they tell you you need to get certain CECs every year to keep your certification, but is that legally true? Are you an employee or a contractor, or are your staff employees or contractors? And how can you tell? Even if someone's on a contract, they may actually legally be an employee. Cory goes through all of that. Is teaching online different to teaching in person from a legal perspective? And legally, is a Pilates instructor considered to be some type of fitness instructor or something else? And finally, we talk about non-compete clauses. What are they and how binding are they? All that coming up on my chat with Cory Sterling. Hey, Cory. Nice to have you on.
Hey, Raph. How's it going, Raph?
It's going awesome. Thanks for chatting.
Thanks for having me. It's lovely to meet you.
Yeah, likewise. Hey, could you please give our listeners and viewers just a brief sort of history of, how you came to be here and how it is that you describe what it is that you do these days?
I studied law in Australia at Bond Uni, where I played Aussie rules football for the Bull Sharks, up the Bull Shacks, up the Shackies, which was a really great experience. And I loved living in Australia, and I traveled a lot before that. And then I tried to do the normal thing of working, getting a good job, working for a good law firm, all of that stuff. Never fit. And and I just wanted to. The idea was to be a lawyer and start a law firm that I would want to work with myself. And I think that's something that I look for in all businesses, totally based on the user experience and just like, why can't we recreate it or why can't we do it a different way? So being a sports nut my whole life, I used to work in the NFL. I love NHL hockey. I love the Toronto Maple Leafs. So sports has been my life. And I just decided that I was going to try to start a legal practice around it. It originally started with yoga because I was in love with yoga for 3 or 4 years. I started doing yoga when I was in law school because, the environment in law school can be super competitive and intense, and everyone's priorities are placed in different focused in different areas than they would in any other normal part of society. And so I just learned to breathe in law school, and the idea came to start working with yoga professionals. And then that sort of just evolved to, working with Pilates studios and working with spin studios and gyms. And it's evolved into dance and massage and and it's been it's interesting because it feels like I started yesterday, but it's really been about 5 years of nonstop work. And the whole idea is to make law simple for health and wellness and fitness professionals, because the one common theme for all of them is that they've all got a good heart. They all want to help people either be healthier physically or mentally. And very, very few of them understand the legal repercussions of operating a small business. And it doesn't have to be something hard or complex, but it's something that there is a degree of attention that needs to be given to it. So I guess I'm here today to share some information about my experiences working as a small business lawyer with health and wellness and fitness professionals, and maybe sharing some insights about, the industry that I've spent 5 years working in. And I hope, and I hope some of the information will be applicable and helpful.
In your book, you talk about things that actually a lot of topics that we touch on in the podcast, which are around. One of the things that struck me is you mention that a lot of you talk about yogis specifically in the book, but I think it's just about everything you say in the book is equally applicable to Pilates. That there's a real fear of or an avoidance of confrontation, like having hard conversations, and that kind of extends to clarifying expectations in the form of contracts. And, the attitude of like, oh no, the universe will provide, the universe will look after it. We don't need to have a contract about that sort of thing. Or I don't need to have that hard conversation with that person, that hard conversation that kind of makes me feel uncomfortable, at the thought of it. And so, a lot of what you wrote in the book really resonated with me and my experience in the Pilates world. But I just kind of want to leave that as a teaser for those listening, because I've read, not 100% of your book. I've probably read about 2/3 of it so far. And I think it's freaking awesome. And I think if you're listening to this and you are in the Pilates world and you're an instructor or a studio owner or both, you would probably benefit from reading this, unless you feel 100% confident that your legal, this legal side of your career is totally under wraps. But I want to leave that as a little bit of a teaser, because you touch on a lot of really important stuff in the book, like contracts, agreements, and liability waivers and things like that, which are very important. But I wanted to ask you today about some things that are really super specific to Pilates, and they've just been really, honestly, bugging the shit out of me for a bunch of years, and I've just been wondering about this stuff. And the first one is, in the Pilates world, now I don't know if it's the same in yoga at all, but in the Pilates world, we've got this kind of, I think it's a cultural thing, where we say you have to be certified on each piece of equipment, right? So, in Pilates, there are a bunch of bits of equipment. You've got mat work, you've got reformer, Cadillac, Wonder Chair, the various barrels, pedipools, different bits of equipment that we use, towers, wall units, whatever. And so the way the industry is set up is such that you get certified per piece of equipment. So you might be a certified mat worker instructor, or but that doesn't mean you can teach reformer, right? So if you can teach an exercise called the 100 on the mat, doesn't mean you're qualified to teach it on the reformer or the Cadillac, which it's essentially the same exercise on each piece of equipment. And there's a lot of, I see questions pretty regularly on social media forums about this, like, oh, I'm trained on the reformer, but my workplace has a Cadillac and I want to teach the client the 100 on the Cadillac. Am I allowed to do that? Am I legally, leaving myself open to litigation if I overreach my scope of practice in that way? And I'm just always reading this and scratching my head and going like, is that an actual scope of practice thing, or is that just a commercial device that the education companies have put out to like make you want to buy more education before you, what would happen if I just walked in and I'm not trained on the Cadillac and I just start teaching on the Cadillac? Like, what's going to happen?
So I'm excited to answer this question, and it's a wonderful question. Before I do, I'm just curious, what do you think the answer is?
Well, I'm no kind of lawyer, but my layperson's kind of just like common sense understanding of that. I mean, I understand a little bit about the concept of scope of practice and duty of care. So I think, my view is that it's probably, if I was up in front of a court and they were saying, well, can you justify why you taught someone on the Cadillac even though you weren't trained on the Cadillac? Well, if I could show a rationale for doing that and that it was within my competence to do that, it was within my scope of practice, as in I wasn't, overreaching my remit, like I wasn't diagnosing their condition or, prescribing medications to them or whatever, my view is it'd be fine.
Okay, cool. I like that. And the first part of the answer, the first part of the answer is going to be like a bit more draconian in what the actual answer is. And then the second part's a little bit more fun. But the answer to the question is that all of it depends on who the certifying body is and how and where they are established, right? So when you look at something like a nutritionist or a dietitian, let's say, and I think this would be ubiquitous across the United States and Canada and Australia. Let's just use those jurisdictions, right? So if you're going to perform certain activities and the government has a regulated board that either is federal or is run by the state, they're going to have a certification process where they're going to say, okay, anyone who is allowed to do ABC, in order to do that, you have to go through our vetted and certified process to learn these skills and these abilities. If you're going to diagnose, if you're going to treat, if you're going to, inject a needle to take blood, whatever it is, that there's all these, fine lines. But all of those are because those are government regulated industries that have their own certification processes, and there's a lot of red tape around them, and there's a lot of problems if you cross those boundaries when you're not supposed to, right? When it comes to something like Pilates, and this is the reality is that there's not a certified, a government or like a governmental organized run Pilates board that will oversee what anyone who's practicing Pilates has to do and the way that it has to be done. And so as a result of that, if you were, and that's so the first part of the answer is that like the question always is, if you're allowed to do something, the first question is, who is the licensing authority? What is the process that they have in place in order to give a license? Do they restrict what people who do not have a license can do? And is there a piece of legislation around that? Because that is, first and foremost, that's where the issue is going to come up. So, Raph, in your example, where you're like, okay, if I was in front of a judge, this is what my response to that comment would be. You would only be in front of a judge if the person that you were performing the services for suffered damages. Whereas it is possible that if you're a practitioner and you're doing something out of scope, like diagnosing or treating or whatever it is, it may not be the end user or your client who's frustrated that would have a complaint with you, but it could be a governmental body that is observing your practice, following you on social media. And then in that case, it's not just managing the relationship of you and your client. Mm-hmm. So the first answer is, who is providing the certification? Is there a piece of legislation around it? And if so, what are the boundaries around that? The next part to the answer, I would say, is that acknowledging that if there's going to be a complaint against you, it's going to be made by one of your clients, right? Even let's say there's a studio down the street and they know that you don't have a Cadillac certification and that you're doing Cadillac and you're doing the 100 on Cadillacs, right? If they're going to lodge a complaint against you, who are they going to lodge that complaint to? Who's going to pursue it? What would the remedies be? What would the damages be, right? It's like at law, the one thing I always treat, it's about like, first question is, what relationship are we in? And what communication around expectations do we have in that particular relationship? So the thing that you'd have to know is the real risk that you run, unless there's a Pilates, if there's a Pilates governing body that gave you your certification and you signed an agreement, a licensing agreement or a use agreement that being a representative of their brand and using their certification, you're only going to offer services for what you've been instructed or certified to do. Outside of that situation where someone could allege breach of contract against you, those are almost all of the legal possibilities I've explored of what could happen. It's really just about the client. Mm-hmm. So what I would say, my practical answer, because I'm all about practicing practical law, the practical answer to that question is, what have you represented to your client? Do they understand what they're getting into? And is there any documentation around the representations and warranties that you've made? Mm-hmm. An example of where you'd be at fault or where I could see you running into trouble is you have a service agreement or a studio membership agreement that you have all of your clients sign. You don't mention anything about your certifications. You tell them, oh, it's cool. I got this. I can do all of these things. I know how to do all of these things. You're not certified for the 100 on the Cadillac. Something happens while they're doing that. They get injured. Firstly, you'd still be covered by the waiver of liability. I think it would be very, very difficult for them to be able to penetrate that. But like the only potential, they could maybe allege fraudulent behavior on your behalf or misrepresentation. So unless it's overseen or governed by a governing body that's, supported by legislation or an official authority, my inclination is that a lot of it is a marketing practice. They want people to enroll, and nothing against the industry. I understand why it makes sense. And I think the pragmatic approach of having people specified in all of these industry, like in all these particular exercises makes sense. But like, it's sort of like, oh, well, you did this, but now you have to do this. And then you have to do this. And then you have to do this. Whereas if you're like, hey, I'm Raph, I've been in the Pilates industry for 20 years. I don't have my Cadillac certification, but I've worked with hundreds of people. No one's got injured. Here are my qualifications. This is what I can do. This is what I've studied. If you feel comfortable, this is what I'd like to put you through, and let's see where it goes. And please sign this waiver of liability, acknowledging that I've brought all of the risks to your attention. So that would be my answer to your question.
So let me see if I can unpick that, or let me see if I've understood you. So there are certain professions that, in various jurisdictions, so whether you're in the US or Australia or Canada or whatever, are regulated by law. So and what that means is there's an actual act of government, there's an act of Congress, an act of Parliament, whatever it says, a legal instrument, a bit of legislation that says, if you want to be a insert profession here, let's say a physiotherapist, right? If you want to be a physiotherapist, or let's say, used to use the example of a dietitian, right? If you want to be a dietitian in this jurisdiction, well, you've got to, fulfill these requirements. You've got to attend a 4-year university degree that meets these criteria. You've got to pass our government board certification exam, and you've got to blah, blah, blah. There are these specific things. And then it says that, okay, and then the legislation goes on to say that only dietitians who meet these requirements can give specific dietary advice to people. Right. And so if you don't meet these requirements, if you're, say, a personal trainer or whatever, but you're not a dietitian, then you can't give specific dietary advice to your clients. Have I understood that correctly?
Yes, that's correct. And that's why in an agreement, you'd use words like best health practices instead of coming up with a diet for you. There's all these different ways that you'd want to communicate it differently. But I just want just to zoom out and look at the big picture of where all of this comes from at law, just so you know the policy behind it. It's all about protecting the public from misrepresentations, because a lot of the times there will be, there will be people who want to promise quick fix solutions, or that they can get something done for you, or they have a cure for something. And so all of the case law in these areas, it's not like, oh, this person didn't have a Cadillac certification and was offering services on the Cadillac. It would be someone like, oh, someone had a terminal illness, and another person came along without any certification and offered to give them remedies or medicines and promised them that they would get better. That's what, right? Because yoga and Pilates and a lot of the industries that we work in, there isn't a bulk of case law around it, either because there's a propensity to settle, and these are the types of people who don't want to pursue legal action, or it's just such a small area of law that it never really gets to judgments, which then are released to the public. For whatever reason, the examples that we see in case law are extreme. But then as a lawyer, you have to extract the principle and be like, okay, well, what were they really trying to say? What are they trying to protect from that?
Right. And so that kind of gets to the principle that, that the governments are deciding, which professions to regulate based on what's the risk profile, right? So if I'm an oncologist, a cancer doctor, right, and I prescribe the wrong medication to someone because I've read it in some fad magazine or whatever, well, that's a big, that can have very serious consequences for the client. Whereas if I'm a Pilates instructor and I teach the 100 wrong, that's not going to have very serious consequences for somebody, medically speaking. And so that's why there's no regulation of the Pilates industry. If I want to call myself an oncologist, I've got to go to university for 12 years and fill all those board requirements and whatever. But if I want to call myself a Pilates instructor, all I've got to do is paint Pilates instructor on the front of my shop and off I go, right?
Correct. And you would just need someone who would you'd need someone who would want to work with you as a Pilates instructor. You could say to them, hey, I have 0 Pilates certification. It's all about representations. It's all about communicating openly and honestly. I've practiced Pilates myself for 2 years. I don't know anything. I've never done a certification, but if you want, I can teach you the things that I've learned. And a consumer has the choice to participate in that or not. No one can restrict that. That's a liberty for one person to offer something, another person to accept it.
Right. So if I have on just say, all right, let's get down to a really kind of what I consider to be a realistic example in this scenario. So just say I'm an instructor at a studio and I've got my bio on the website of the studio. And it says, Raphael is qualified in mat work and reformer, from XYZ company. And, that's publicly available. And then you book in a session with me and you sign your liability waiver, right? and then I'm like, oh, hey Cory, want to come over here and do some stuff on the Cadillac? What's the situation there? Have we been transparent enough?
Yes, I think I don't think you've made a misrepresentation. I think it depends of what content is included in the waiver. Mm-hmm. If the waiver mentions the Cadillac as an activity and you describe what the risks of those activities are and what the outcomes of those risks are, and someone still voluntarily participates, from my perspective, you've told them what they're doing, you've told them what the risks are, and they've accepted those risks in participating. You don't. Yeah, I think it would be very, very, very difficult for someone to bring forward a case. And just one thing I want to add on this, which is a really practical component for all of this for Pilates professionals, is insurance, right? A lot of the times an insurance company will ask for a certification or will want to see your certificate or want to vet your practice based on what, wherever you received a designation or your experience. So if you don't have insurance, everything is riskier. And in order to get insurance, often you'll need to provide the appropriate credentials that an insurance company deems appropriate so that you can offer those services. So that's sort of one way of sort of a bit of a safety net towards it. But based on your example, I would not have a problem if a client of mine put a disclaimer on their website saying Raphael is trained in mat and bar, and then you do things on the Cadillac if your waiver specifically mentioned the Cadillac.
I mean, I think it kind of, to me, it feels like in the parallel in the personal training world would be like, okay, well, if I come to your fitness boot camp, and you're a personal trainer, and in your personal training course, you learned how to do, dumbbells and machine weights, and you learned how to do body weight stuff, but they never specifically mentioned, say, the fit ball, the Swiss ball, right? And you think, you know what? I think Raph might enjoy doing some exercise on the Swiss ball today. And then the Swiss ball bursts and, it's like that just seems to me like a ridiculous example of course you can teach on the Swiss ball. It's not rocket surgery.
Yes, it's all, however legal we want to get, it's about duty of care and it's about standard of care. And if Raphael has 2 certifications in Pilates, but not 3, I don't, to me, that doesn't seem that you're falling below the standard of care, assuming that everything was done properly. And if there was a mistake, accidents happen. That's just the nature of how everything works. But the more that we go into this, the less concerned I am about it.
All right. So, well, that's good. That kind of seems to me that confirms my pre-existing bias on this topic.
Yeah, and I don't want to emphasize the point too much, but just remember, Raph, it's all about the communication with the client. Uh-huh. It's all about you telling the client, hey, this is what I've studied. This is what I do. Are you comfortable if we try this? Mm-hmm. If sign a waiver, if you've been transparent about what you do and what you don't do, and they choose to participate, it would be very, very, very difficult for someone to hold you accountable in that situation.
Okay, coolio. So, all right. So we've touched on this topic, within this conversation already, but something that I wanted to sort of just clarify then is, like you said, in all of those countries that you've mentioned, the US, Canada, Australia, New Zealand, I think in the UK as well, pretty sure, there is no legal instrument, there is no piece of legislation that specifically regulates Pilates, right? So if you go to, legislation.gov.au, which is this website in Australia where you can look up all of the bits of law, it's like type in Pilates, not a thing, right? It doesn't come up. There is legislation covering, like I said before, so dietitians or physiotherapists or chiropractors or whatever. So Pilates is kind of invisible to the legislation like that. So at law, is Pilates considered like just kind of some form of fitness instruction? Like, what category do we fall into?
I don't have a definitive answer, and I imagine that it would vary from jurisdiction to jurisdiction. To me, I think it would be recreational activity probably is where it would fall under, or physical activity or recreational activity.
Right. And so, presumably, I mean, I'm totally unfamiliar with any legislation around that area, but presumably, if that is such a broad category of things, that any legislation there would be pretty generic, I would imagine.
Yeah, I'll give you an example. So when I wrote the yoga law book, and I specifically the chapter on waivers of liability, I did a lot of research into case law in a lot of different jurisdictions. So the Supreme Court, the High Court of Australia, the Supreme Court of Canada, the High Court in the UK, and what I found was there was nothing on yoga, there was nothing on Pilates. But there are like the best that we get is like someone gets injured on a ski hill while they're skiing, and is the resort liable? If so, did the person sign the waiver? Why would the waiver apply? Why did it not apply? Those are the cases that you get. And I think that what I've had to do, it's been a challenge, and it's been a blessing, but there aren't those precedents in case law around Pilates. And I really don't foresee it happening. I don't see there being a massive seminal Pilates legal case that changes the landscape. And, there's 7 justices sitting on the bench, and they go into a whole discourse about Joseph Pilates and the pillars, and like, it would be cool, but I don't think it'll happen. So that being said, what you have to do at law is you have to look, and as a lawyer, it's always about, in a hypothetical situation, let's say a Pilates case does go to court, and the parties are not going to settle, and there's going to be, there's going to be a defense, and then there's going to be a prosecutor who's bringing the case, or a complainant and a defendant. Okay, they're going to look at the different case law that exists, and one of them, whatever, depending on the argument they're going to make, they're going to want to show why Pilates is similar to these other cases that pronounces a particular law around this. The other party is going to say, no, Pilates is different because you do it on a mat and there's no motor involved. And that's when lawyers are really lawyers. I'm like a pseudo lawyer because I don't get into that depth of level of things, but it would be about one person trying to make an argument of why Pilates would fit to a particular precedent, and one trying to distance itself from that precedent.
So it's kind of like the blind man and the elephant, where one lawyer is saying, Pilates is really like skiing at a resort because we can see blah, blah, blah. And the other lawyer going, no, Pilates is not like skiing at all. It's more like participating in a fitness class at a gym, and because that suits my argument better, right?
Yeah, exactly. So until that moment comes up where there will be a case where there's a judgment that's released to the public where they go in detail about Pilates, which I don't see that happening. Until that happens, we'll never know. And in the meantime, it would just be conjecture, or how crafty someone could come up with a legal argument about why it is a recreational activity or why it's not, or why it is a physical activity or why it's not.
Right. And I know that you were in the context of what you just said. You said, there hasn't been a big legal case about Pilates. You were talking about liability for basically errors and omissions, professional indemnity situation. But as you're probably aware, there has been a big Pilates case related to the use of the term Pilates to represent a business type, and that was involving Sean Gallagher et al. In about 2001, I believe. But that wasn't related to liability or, which category of thing Pilates is. It was just about, is the word Pilates something that you can trademark or copyright?
Yeah, exactly. And the reason why I have a particular area of focus because relevant to the issues that my clients face. So as an example of something that I don't deal with, which I would imagine there probably is some case law somewhere, probably around assault or harassment, unfortunately around assault or harassment or consent for touching related to Pilates or yoga. I know that there are cases of things that come out like that, but I don't really focus or pay attention on that because for the most part, those are things that don't relate to my clients. So it's not that it's not sui generis from law in general, but in the specifics of running a small business, we don't have those judgments available around the practice areas that we work in.
Right. And that's probably, in my estimation, because we don't have those judgments, because Pilates is just simply so freaking safe that no one breaks their neck doing it. No one dies of cancer because they got the wrong Pilates exercise. So these things simply don't go to court.
What I will say is I have in my years, there have been a lot of crazy stories, a lot of unexpected things that happen that you would never think would happen, but anything can happen.
All right. So, it seems like Pilates is really in a, legally, it's really not in a category, or it's in a nebulous, a broad set of categories potentially. It hasn't really been established at law, which category it falls into, because there is no case precedent and there's no legislative instrument, specific to it. So, where does that leave? Where does that leave the organisations that certify people in Pilates? So there are many organisations that. So if you want to be again a dietitian, you get certified by a government authority, right? Whereas if you want to be a Pilates instructor, you get probably certified by a private for-profit, company. Or possibly by the PMA if you're in the US, which is the Pilates Method Alliance, which is a not-for-profit, but it's a private organisation. It's basically it's an optional club. I guess it's kind of like the Yoga Alliance or something like that. Mm-hmm. It's has no government mandate. It's just a self-appointed kind of industry peak body. So yeah, what is so if I'm if I want to be a member of the PMA or not, or if I want to maintain my Stop Pilates certification or not, like what's the kind of legal status of those organisations?
If it's a nonprofit, or if it's an organization that is private and that has created itself and then creates its own certification and creates its own review for certification, it's really what you want to look at as an instructor is, what is their reputation? How well is it known? Are they trustworthy? How up to date are the materials? All those are sort of the sort of things that you need to know. But, and again, I'm sorry that I feel like that the answers are somewhat dissatisfying just because there aren't really those answers. But this is what I can tell you. Practically, you're going to want to make sure that you're covered by your insurance, and that whoever you're working with, or whatever you're working with, whatever organization is acceptable and deemed appropriate. But I'll just give you an example slightly outside of Pilates. I used to be a spin instructor. Mm-hmm. And so I wanted to work at a couple of gyms, and the gym said, okay, we're only taking instructors who have Schwinn or this or that type of certification. So then for me, I was like, okay, well, if I want to work here, obviously I have to get this type of certification. And that's sort of what informed me in my decision. And then okay, if Schwinn, let's run through a scenario where you do a certification, and they say the certification is only good for 2 years, and then it needs to be renewed every year, right? If you need to have that certification for your insurance or for your employer, then you better renew that insurance. The legal repercussions, no one's coming to look for you if you don't renew your Pilates certification with PMA, but it may affect your ability to retain clients, to keep your insurance, or to work at a particular place. But again, if someone could have none of these, and people, let's say they can touch their toes, and I know Pilates people can do a lot more than just touching their toes, but let's just say someone was like, hey, and I know because I had my own Pilates journey where my goal was to touch my toes. I'm 6'3". I didn't touch my toes for 15 years. And I worked with Leo, my Pilates instructor, and he changed my life and all the things. And Leo's based in Brazil. I don't think Leo has any Pilates certificates. He might, but it was more like he was my friend. He's like, yeah, man, I can help you touch your toes. And he had a reformer and all this equipment. And I was like, cool, let's do it. And
no liability waiver.
It was in a small town in Brazil, and it's not my business. So it's his business, but, and nothing happened, which was great. But that's just an example where this is a private enterprise. Yeah. These are unregulated industries. It's about two people agreeing to something, and someone could totally say, hey, I use Pilates to touch my toes. If you want to come work with me, I've never been certified. I've never done a training. But I've helped 5 people touch their toes, and I can do the same for you. Does that make sense?
Yeah. So, all right. So you touched on this, but I just wanted to sort of double click on it. So the PMA is a slightly separate case because they're a not-for-profit organisation. But what about a for-profit organisation? So I'm thinking specifically about Stop Pilates because I'm certified through Stop Pilates, which is headquartered in Ontario, Canada. And so I did certifications with them, and I've still got the certifications. They're in my filing cabinet somewhere. And every year they send me an email that says, "Dear Raphael, you need to complete," I can't remember the number, but let's say it's 15 hours of Stop Pilates branded continuing education. So I have to go and buy their DVDs or attend to their branded workshops or, whatever it might be in order to accrue those 15 hours in order to, quote, maintain your certification. So, but, I don't know, I probably 6 or 7 years ago, I just stopped doing that because I also have other certifications, like I'm an exercise physiologist, I'm certified in a different Pilates organisation, and it's like each Pilates organisation insists that you only do their particular brand of continuing education. And so if I go and do like an anatomy course or biomechanics course for my exercise physiology CECs, that's not acceptable to these Pilates organisations. So anyway, I decided I didn't want to do triple CECs every year, and so I just decided to not do the Stop Pilates ones. So, now I don't actually care about my Stop Pilates certification anymore, whether I can use it or not, because I've got plenty of other certifications. But I see a lot of people getting anxious on social media about like, oh, I haven't done my CECs this year. Are they going to revoke my certification? Will I, not be able to teach my clients? Like what's the legality around that?
The only thing that they could revoke is your ability to make a representation that you are certified in through their particular method. Mm-hmm. And again, the one thing I would say is when you signed up, like, did you sign a licensing agreement? So licensing agreement would mean they're letting you use a particular name, that you make a representation that you're certified by them. But if that certification is not in good standing through their perspective, then they can revoke that license and you'd no longer be able to make a representation to the public that you're certified through that particular organization.
Uh-huh. So, all right. And so maybe this gets to a fine legal point, which I'm hoping you'll be able to help me clarify. When I was, when I was, working within the Stop Pilates multiverse, they had the distinction, and I honestly have no recollection of what I did or didn't sign, when I did my certification, but they had this distinction that if you had completed the training but hadn't yet completed the certification exam, you could refer to yourself as Stop Pilates trained. Whereas once you completed the certification exam, etc., then you can refer to yourself as Stop Pilates certified. So, is this a case where so now, a decade later, I'm, according to them, I guess I'm no longer Stop Pilates certified because I haven't maintained my CECs. But can I still say, I was trained in the Stop Pilates method?
Yes. Assuming that everything that you told me is correct, yes. Because once you complete the training, you don't need to renew the training. You need to renew the certification. I'll just speak honestly. What I see in all of the industries, not just in Pilates, is that anxiety that the teacher has, usually that comes from maybe a lack of business acumen or experience. And it may just be a company or an organization maybe not intentionally exploiting that, but certainly propelling people to, trying to drive people to stay part of their particular method. It's so competitive, it's unregulated. To me, just hearing you say it, I'm like, okay, firstly, legally, there is a distinction between trained and certified. We've acknowledged that. So you're good if you say that you're trained. But like, if people are scared on social media, they're like, oh, is my certification going to be revoked? Like it might, but there's a lot of other things that you can do and everything's going to be okay. Like don't get intimidated to think that your world's going to end. If you speak to them about it, they're going to tell you how terrible it is. But then if you call another certifying organization and ask them, they're going to be like, no, come with us. You don't need to do that. So it's murky waters and everyone has an interest and their own, interest in play.
And if you from experience, if you put on your website or your bio or whatever, I am trained through Stop Pilates versus I am certified by Stop Pilates, 99.999% of the public who read that will make no distinction between those two terms, right?
The number is higher, the percentage is higher than that.
So it's a distinction without a difference, really.
But it's marketing, man. It's so much of these industries is marketing.
Yeah, 100%. All right. Well, this is good. So, all right, and another one that I see a lot, and this is something that I think there's a bit of controversy about this in the industry at the moment, both in the US and Australia that I'm aware of, and I imagine it's probably the same in the UK and Canada, is this contractor versus employee scenario. So the common practice in the industry in the US and Australia, I believe, is to basically to engage people, instructors, as contractors. So they sign a contract that says you will provide Pilates services for X number of dollars per session or whatever it is, and then basically the instructor has to provide their own health care if they're in the US, they pay their own superannuation, their own pay as you go tax, all of that stuff. The onus is on the instructor, whereas as an employee, the employer is responsible for those things, and there's a lot more protection for the employee around unfair dismissal and holiday leave and sick pay and stuff like that. And so in Australia, I've looked into this a fair bit. We've got a website on business.gov.au or fairwork.gov.au, which basically has a little tool on it which says, like, are you an employee or a contractor? And takes you through all these things, like, do you have regular shifts? Do you supply your own tools? Do you supply your own uniform? All of this kind of stuff. And at the end, it pops out and goes, you are probably a employee or contractor or whatever. And basically, I think pretty close to 100% of Pilates instructors, in my view, if they went through that test, they'd pop out as an employee, de facto, But the fact is that actually most of them, I think, are not employees. Like, technically, they're actually engaged as contractors. So, do you have a view on this, and how can we start to untangle this?
It's a complex issue, and it's even when you start peeling the onion, it even becomes more complex, because there are legal repercussions for the classification of contractor or employee that are not just face value of, oh, I'm calling them a contractor, so now they're responsible for this, or I'm calling them an employee, so now I'm responsible for this. That is a first degree consequence of the classification. But in the event of misclassification, the consequences can be extremely grave and very dangerous, almost always for the employer and not for the worker themselves.
Just to interrupt there,
Yeah.
I'm sorry. So when you say misclassification, you mean, like, just say I'm a Pilates studio owner and you're an instructor, and you come and work at my studio, and we sign a contract. So you're, technically you're, on the face value, prima facie, you're a contractor, right? But in all respects, you actually behave as if you're an employee. You do regular shifts. I provide the uniform. You don't provide any tools. All of that. You have to ask permission if you want to take a holiday. All of that stuff. So is that what you're talking about? So, like, the face value?
Yes, misclassification of a worker when you call someone a contractor, but you treat them as an employee. And just so you know, in almost all of the jurisdictions, there's something called the control test. So that's probably what you went through on business.gov.au. But the question always is, how much control does the employer have over the person who's doing the work? And that's why it's things like shifts, increased payment for better job performance, hours, ability to subcontract the work out, what the nature of the work is versus what the nature of the work they're doing versus the nature of what the business is. And so what the signed agreement states is a factor in the equation, in the evaluation. It is not a determining factor by any means, because if you could just call someone something and get them to sign a piece of paper that said they were something, but really you were treating them completely differently to that, then anyone in the world would be able to get away with it. Mm-hmm. So a signed contractor agreement is a factor to be considered. What was the intention of the parties? But I can tell you that it is it's weighted significantly less than a lot of other factors, right. Specifically like invoicing, ability to subcontract.
Right. Sorry. Can I just unpack that? So, like, if I engage a plumber to come and fix my sink, right? Exactly. And I ring up John. If I ring up John's Plumbing, okay, and John answers the phone, and I say, "Hey, John, I want my sink fixed," and he's like, "Okay, yep, I can be there in an hour." And then in an hour, Steve rocks up to fix my sink, and I'm like, oh, who are you? And Steve's like, oh, I work for John, right? I'm like, okay, fine, it's not John, but Steve's going to fix a sink. So Steve fixes a sink, off he goes, all good, right? Whereas if I'm a Pilates, so that's a contractor situation, like I'm contracting that plumber to fix my sink, right? Whereas if you're a Pilates instructor and you work at my studio, right, and one day, you don't show up for your shift, but Mary shows up, and I'm like, who the hell are you? And she's like, oh, I'm Mary. I'm like, well, what are you doing here? And she's like, oh, Cory sent me, to do this class. I'm like, no, this is Cory's class. I didn't employ you. I want Cory. I paid for Cory, right? So is that what you're talking about the ability to subcontract?
Yes. And the one thing that you have to know about all of this is that it's always a balance. So and I'm going to talk about the consequence of misclassification in a second, but just so you know that it's always, and you can have you could have a contractor relationship where someone is not allowed to subcontract, or you limit who they can subcontract to. Mm-hmm. For example, you're allowed to subcontract to any of the other teachers on the roster. Mm-hmm. So it doesn't have to be Cory who shows up, but it could be Marianne or, Derek or whoever it's going to be.
But not just some random person that you found on Craigslist.
But also it could be, and it probably in a true contractor sense, it could be. Mm-hmm. So I think the best way to explain the distinction is often to look outside of the industry to see how it works. So just like the example that I'll often use would be the woman who's the graphic designer for our law firm. Her name is Mallory. We've worked together 3 years. I've never met her. I don't know if she's real. I don't know if she's a robot. Her WhatsApp.
She might be some guy in Lithuania, in a basement.
Exactly. But Mallory, I asked her to do, I'm a law firm. The bulk of what I do is offer legal services. She's a graphic designer. She's doing something outside the scope of what it is that the main service of my business is, which is a really important factor. More and more that's becoming a trend, especially in the United States. So what is your business and what are you contracting out for?
Right. So if she was a lawyer,
yes.
And you're a law firm, that's different.
It would be different because then the specifics of how much control I have over the way she's doing the services would need to compensate or address, would need to be that much more obvious so that she would in fact be deemed a contractor, not an employee. Mm-hmm. So she could work whenever she wants. She can work from wherever she wants. Because it's law, she probably couldn't be able to contract out, but that's like a specific nuance to law as opposed to other things. I don't get to tell her how to perform the services. The clients who she works with could be retained for hers. I likely would not be able to include a non-compete provision into the agreement. And those are, she has to use her own equipment. I wouldn't provide her with a uniform. She would have to invoice me instead of me paying her automatically. And just like you need, let's say there's 9 factors. Mm-hmm. If there's one that's really heavily against you, you'd want almost all of the other ones to balance out so that you're showing that in fact you are treating someone like a contractor.
So if I'm an instructor at your studio and you tell me, which shifts I've got to work, and you don't allow me to just send in someone else in my stead. And if I use your reformers and your mats and your fitness balls and whatever, and if you've got some rules around which exercises I can and can't teach in your studio, or how we do things around here, in terms of teaching Pilates, that pretty strongly suggests that I'm in fact an employee, right?
Yes. And the biggest of all of those is how much control do you have over the services? Mm-hmm. So if you're like, hey, in every Pilates class that we do, we always start with the magic circle, and then we always end with mermaid, right? Whatever it is. And you say, this is exactly how the services have to be done. That's an example. That's the strongest indication of an employee. Huh. Whereas opposed to it's like your class, rock up, do whatever it is that you want. It's all good. Right. And make sure the clients are happy.
If you walk past one day and I'm teaching, I'm like, you're like, phew, everybody's doing headstands up against the wall, whatever. And you're like, I've never seen that in a Pilates class before. That's like that's an example of, if I was a contractor, that you would be like, oh, cool, Raph's doing some cool stuff in his class. Whereas if I was more an employee, you'd be like, hold on, that's not the way we teach Pilates here.
Yeah, and you'd also it's so much of great relationships is having great agreements. So even if you have a contractor agreement, you'd say the services should be provided as per professional Pilates standards. Mm-hmm. So then if they're doing something absolutely crazy or something totally outside the scope, like let's say as an example, and this is like what being a lawyer is, how you have to think, if they're doing an activity that's not in the Pilates certification program or training, right? And they have an agreement saying that they're going to offer the services that would be, standard Pilates, a standard Pilates class, and they're doing something outside the scope, you would have grounds to speak to them and say, hey, I saw that you were doing handstands. In all of the Pilates trainings we've done, handstands are never taught. In the future, please don't do that. That would not mean that you're controlling the way the services are, because it's a reasonable request. You're not being unreasonable. You're still letting them choose the sequencing and how many repetitions and what they do and what the breath count is and any of that related stuff. But the moment that you tell someone how they have to do something and like sequence and specifically what needs to be done, it's more of an indication as an employee. And the trend that I've seen for Pilates studios across the board after the pandemic, or in this, wherever we are in this whole saga, is just that more people are moving to employees because they want to control their services more. Whereas before they were more relaxed and they didn't care, but now health and safety is different than it was before, and their clients are looking for a different type of service, so they want to have more control. And as such, they used to have a big roster of contractors, and now they'll have a small roster of employees.
Mm-hmm. One thing you touched on there a minute back is non-compete agreements. So you said basically, from memory, that if I'm a contractor at your studio, then you probably can't hold me to a non-compete agreement by, if I just kind of go away and take some of your clients with me. Can you expand upon that?
Yeah, non-competes are a really, really hot issue. I was just interviewed on NPR radio in the United States earlier this week about it, because, and not to be too much United States centric, but Joe Biden passed an executive order basically trying to prohibit non-competes, or saying that they're going to start the process to eliminate non-competes from all agreements, whether employee or contractors. The way that you want to think about a contractor is, the plumber Steve, who's coming to fix the sink. And is it right for you to say, hey, Steve, if you're coming to fix my sink, you're actually not allowed to fix anyone else's sink? Right?
That seems pretty ridiculous.
It doesn't make any sense. But it's so common in the industry that people are very protective. They're a little bit fear-based, and they think that, if I bring on this instructor and they're great, then they're going to take all of my clients with them. So just to unpack non-competes, the question is always going to be, is the public interest being served? So the competing balances here are the business owner that is opening up their business and their books and their clients to a worker, and the risk that they run of losing all of those because they bring someone on who may steal them, versus a person's ability to make a living and offer services in the profession for which they operate. Any non-compete provision will have to have three elements. One is the duration, so how long you're trying to prevent someone from competing against you. Geographic scope, over what area are you trying to restrict them from doing this, and what the specific services are. So what are you specifically trying to prohibit them from doing? All of the issues that will come up around a non-compete would be the employer saying that it's reasonable and fighting to enforce it, and the staff member challenging and saying that it's unreasonable and that they can't work as a result. So it's there, like many other things, it's very, it's gray. It's a very gray area. It will often be a question of fact, and looking at it and saying, okay, well, in downtown Sydney, there's, 37 yoga studios, and you've tried to put on a non-compete for 2 years not to work in 15 kilometers from where the studio is in wellness and health services. Right? How is this person going to make money? Plus, by the way, this person was working for you 6 hours a week, earning $35 an hour. There's no way a non-compete like that would ever stand up. It just wouldn't.
It's too broad. It's too broad, right?
Yeah, too broad and too restrictive, right? Because you're in a metropolitan city, and so now let's go for an example of something that could work. let's just say Cadillac Pilates. Let's say someone has a studio where all that they do is offer Cadillac Pilates or Pilates movements on a Cadillac. Okay. So if you have someone who works for you, you guide them through a specific training, all about Cadillac movements and practices, and you say, okay, you agree that for a period of 3 months, you will not work in you will not offer Pilates services on a Cadillac for a distance of 10 kilometers from our studio. Mm-hmm. For me, that would be reasonable. I think that it's fair enough. It's not too long that the person could still do anything Pilates outside of that specific element of what it is that they're doing. 3 months is a fair time, and 10 kilometers is a reasonable area. Mm-hmm. The last thing that I want to say, and if I'm happy to answer any questions about non-competes, but coming back to this misclassification issue of contractor and employee, if you call them contractors, but you treat them like employees, I've seen two things happen. One, I've seen governmental tax bodies on their own initiative flag a business, do an audit, and actually determine that everyone was employees a long time. You get dinged for a tax, you get dinged for interest unpaid on the tax, plus all of the governmental money that you should have owned for employment. Another situation I've seen is teacher has disagreement with studio. Teacher alleges that they were employee the whole time, and that even though they were called a contractor, they really were an employee. And then teacher goes off and will report that business to the business bureau, to a governmental tax authority, will report them for mispractice, which could lead to an audit as well. When you trying to enforce a non-compete for an independent contractor is almost an oxymoron. It's almost an indication that because remember, it doesn't matter what you call the agreement, it matters how you treat the person. Mm-hmm. So if you have a full-time employee and you're paying them, $70,000 a year, and you have a non-compete in that meets the three criteria that I mentioned, that's something that's reasonable. If you have someone who's working 9 hours a week as a contractor, and you want to go and enforce, and I'm working through this right now with a client, and you want to go and enforce a non-compete against them, as the business owner, I'd be way more concerned about that person, what power they hold in being able to report me as a business for misclassification. Right. So that's why it's such a complex issue, and non-competes actually play quite a prevalent role in all of that.
Right. And I'm actually, now you mention that, I'm aware of a Pilates business here in Australia where that exact thing happened, where a government agency, like just of their own accord, just checked up on them and found that, they were employing X number of people as contractors, but where in reality they were employees, and they made them pay them back wages, back tax, but like for years. And this pretty much, I would imagine, would broke that studio financially. That was like a business ending event for them.
It is. I worked with one client who got a bill from the Canadian Revenue Agency for $350,000.
Yeah, in like payroll tax and whatever that they hadn't.
Yeah, for over 8 years, because look, if the government wants to try to find money from you, and you get an auditor, and that's like, look, if we're talking about the importance of having legal documents and the right types of documents, that's how it makes sense. But that's an unfortunate reality. It doesn't happen often, but it could lead to a business ending event, which is why it's so serious.
So, in reality, it's kind of like humans are very bad at estimating risk, and, that's why we're all, generally much more afraid of shark bites and dying in aeroplane crashes than we are of getting hit by a car as we cross the road, which is in reality way more dangerous. And in fact, we should probably be a lot more afraid of, sugary soft drinks than we are of sharks, because they're much more likely to kill us. But, in this realm, it seems like, people are freaked out about whether they're certified on the Cadillac or whether they're maintaining their Stop Pilates certification. In reality, they should be much more concerned about whether they're paying their staff as employees or contractors incorrectly. That seems like much more dangerous.
It is a danger. You want to who understands the industry and understands the jurisdiction and what it is that you're up against. The other things that just come to mind is like trademark is another one of those that, to me, it's just like it's such low hanging fruit, and it's not going to be a business ending event, but like you not securing a trademark and someone registering a trademark ahead of you for the same mark, you lose all of your goodwill and you lose your trade name and everything that you've worked hard to build up for. But also, like, if you want to sell your business, I was part of a deal where someone was preparing to sell their business and they never registered the trademark, and the buyer did some research to discover that the trademark was registered by another company for that name. And then it's like, the purchase price goes down by 15% in an email over something that's simple. So there are a bunch of things that we can do as small business owners to be best prepared for when these situations might come up.
That's interesting to me, because we're in the process of actually applying for trademarks for Breathe Education, and our first application was actually rejected because we had to show, I can't remember the exact legal terms, but we had to show like sufficient, recognition in the marketplace, or, whatever it might be. And there are other companies in the world with the name Breathe, and we changed our logo in 2016. And so we've got like heaps of history with the name Breathe Education, but we had a different logo associated with that. So all of the documents that we had pre-2016 were basically inadmissible to this process. They didn't kind of count towards the whole application. We had to kind of start from scratch with our second application starting in 2016.
Yeah, look, the way that it works with trademarks is they are tricky, and there certainly are nuances to it. But what I find more often than not is that they want to work with you, but they have rules. Mm-hmm. So that's why it's not like, no, everything's finished, but it just means you have to apply again, and you'll apply smarter and do it better. Yep. But they governments reward those who pursue registration of a trademark for good reason, I believe.
Last thing I want to ask you is something you touched on in a couple of times, which is teaching online. And, in this sort of post-COVID, or I guess we can call it post-COVID, post the start of COVID, time, online teaching has become way more common. And so, two questions. One is, from a legal perspective, is anything different about teaching online than teaching in person? And secondly, in regards to restraint of trade, you said one of those three, key things of restraint of trade was the geography over which it extends. And if I'm teaching online, well, my geography is infinite, right? I'm teaching anyone anywhere in the world in theory. So how does restraint of trade, or what did you call it, a non-compete agreement, how does that apply to an online business?
That's a great question, and the law has not really, from my research, the law has not really caught up with that yet. Mm-hmm. I think that's part of why you see Joe Biden making an executive order to try to eradicate non-competes, because then that element is not relevant. The way the businesses operate now are different than before. And I agree with you with people having Instagram Live. Like, this is how it works in 2021. You have a star instructor, they leave. They don't need to go down the street and put up a, rent, sign a lease, a 5-year lease, buy equipment. Like, they're doing it in their backyard on their Instagram Live, and they've got X number of people watching that are your clients. And like, so even no matter how it is that you try to do it, you'd never really be able to satisfy that, because you don't know where the people who are watching are from. Mm. So I think that's one of the roots. It's like, it's sort of archaic, and it's sort of showing its that it's dated. But the answer to your question is like, I don't know. And it'll be interesting to see when and how that happens, because everything happens online, and everything's only going to happen more online. Just as an aside, like, I'm really curious to see, not with anyone that I know, but just a case about people doing Pilates classes through live social media streaming without a waiver of liability and someone getting hurt. And like, what is the duty of care? What is the standard of care? I would love a pronouncement of law on that, because one of the most common questions we get as everything went online was about social media. I'm like, oh, cool. Like, can I just do a Facebook Live? And I've got a YouTube channel and all these things. And I'm like, okay, I'll have a disclaimer, but it hasn't really happened where there's been like a pronouncement. So I think it'd be interesting to see that. And as you know, law is always evolving. So stay tuned. And I'm sure in some some years knowing how long things take, well, we would get some sort of pronouncement on that. But in relation to the first part of the question, I'm just an insurance guy, even though I don't do anything related to insurance. So if the question is, I'm operating online, how are things different? My first answer would be, make sure that your insurance covers you for everything that you're doing and the ways that you're doing it. And like what I always tell people is, have your favorite snack, prepare your favorite snack, could be Vegemite and toast, right? Do you guys eat Vegemite and toast? I miss Vegemite actually. Or like Avo toast would obviously be an Aussie favorite as well. And you just prepare your favorite snack, call your insurance provider and be like, hey, I offer Pilates online and in my backyard and in my bedroom and in the bathtub. And like, am I covered? Am I covered? Am I covered? And just make sure that you're covered for all the different ways that you're going to be operating online. And then also just when it comes to, if you're a studio, your membership agreement, or if you're a one-on-one teacher, your service agreement, and then your waiver of liability, to make sure that all of these documents reflect the current relationship that you have, which could mean partially being online, partially being in person, only being online. It's like you always want your agreements to be the latest reflection of what your current relationship is. So if you're doing things online, you want to introduce those elements to the agreements as well.
So I guess to sum that up, there is no legal precedent at the moment, but the common sense approach is like, well, one, make sure your insurance covers, the specifics of what you're doing, where you're doing it and who you're doing it with. And two, just, check all of your other, bits and bobs like your liability waiver and your, whatever other bits of documentation you have.
Yeah, I would say it's a little bit more serious than, check your waiver of liability, because look, waivers of liability are always about what are the activities, what are the risks, what are the outcomes. Mm-hmm. You offering Pilates with you observing someone on the reformer right in front of you is completely different than potentially you being on a reformer and then being on a reformer on Zoom, mm-hmm. or even you having evergreen materials or pre-recorded classes and you having zero supervision over the way the equipment was set up, over the safety of the space. If someone's overexerting themselves, realistically, those are significantly, from my perspective, they're significantly different activities mm-hmm. with different risks. So you'd want to be thorough to make sure that's covered.
Uh-huh. And because, a lot of those situations in social media, like where it's a live, say on Instagram, you can't actually get people to sign a liability waiver. So it's really just more of a disclaimer, right? So it's not a waiver.
Yeah, you'd want to have a disclaimer on your website that connects to your social media profiles. If you do things on YouTube, you want a YouTube disclaimer. And that's the best that's the best that you can do.
Right. I mean, I see on YouTube, there are many online Pilates classes that are available freely on YouTube that have like 1 million plus views on them, right? So I imagine if there was going to be a serious amount of litigation around this, it would have already happened.
Yeah, yes and no. The one thing that's interesting about law is that it only takes one.
Right.
It takes one sort of perfect storm of someone getting injured, doing something, alleging that they were instructed to do something that put them at risk and they suffer damages as a result. Mm-hmm. And look, life as a lawyer is very, very interesting because you're introduced to a lot of different people and a lot of different experiences. And one thing I'm going through with a client now is if somebody wants to sue you, they're going to sue you. Mm-hmm. And you can't restrict someone's ability, no matter how right. frivolous a case is. It's a person's liberty and right and an ability to pursue legal action if they want to. How early you can get it thrown out is another story, but there are people out there who are different and want, and they want to spend their time focusing on different sorts of things. And you just want to be as prepared as possible.
Is there anything else that, we haven't discussed that you think, you'd like to share or discuss?
I think this is very thorough. I think we've gone in. This has been a really enjoyable conversation for me. It's not often that I get to really dive deep into some of these different types of topics. So given a soapbox and a platform, I will say that I really do love Pilates. And that when I'm doing Pilates, the one thing I think is why did it take me so long to get here? In terms of doing it. And, I had that experience with my teacher, Leo, who I love. I probably went 4 months, 5 times a week. And that was like, then I started traveling and he started traveling. So we haven't been able to get back to that frequency, but Pilates totally transformed my body more than anything else that I've done. And I think it's fun, and I think it's a really cool niche, and I love how passionate Pilates people are about it. And so I'd say keep going, and whether you're trained or certified, have fun with it and just help people be healthy and restore their bodies and connect with their breath and all of the wonderful things.
What a great parting message. And can you just briefly give us the sales pitch for your book, or just who your book's for and what people will get from it?
Yeah, anyone can go onto Amazon and you just type in Yoga Law book. The book would be for someone who doesn't fully, feels like they don't know what they don't know about the law as it relates to their small business. And it's told in a very anecdotal way. I use firsthand stories of experiences I went through with my clients to take intimidating subjects and bring light to them and let people know that, it's okay, and lawyers aren't all bad people. But most importantly, there are some really, really simple lessons that you can learn. You'll have fun while you're reading, but there are some really simple lessons that you can learn about the law and how it relates to your business so that you don't make the mistakes that other people have made before you. There's no need to. For years, I have the same conversations, and I'm happy to do so, but the information's out there. This is sort of the universe telling you, like, hey, you can take a bit of action to get informed and understand and just get excited about it. Because look, everyone spends so much time on their business. Your business is your life. It's your passion. You wake up thinking about it. You go to sleep thinking about it. You invest so much of your time. It deserves to be treated professionally and protected properly. And so normally this was a very painful and challenging exercise, but I've really tried my best to make it fun, make it entertaining, and make it relatable so that you're going to want to engage and want to protect your business. And again, the whole coming back full circle to the first thing I shared, the reason why I started a legal practice to work with yoga professionals, with Pilates professionals, with fitness professionals, because I know that all of them want to do great things. You want to make people healthier. You care. You want to improve the lives of the people around you and build a community around it. And so I'll just continue parading for this message and bringing attention to simple legal issues that all of us can fix, and then focus on growing and revenue and Instagram and focusing on all the other things that we love focusing on.
Thanks so much, Cory. This has been very illuminating in many areas for me, and hopefully, and I'm pretty sure, very useful for our listeners. So thanks very much.
Cool. Cheers. Thanks for having me, Raph.